the courts in Canada, after very lengthy proceedings, all ruled, and I say all because it was both in the Superior Court here in Ottawa and in the Court of Appeal in Toronto, that there was no evidence to justify his extradition to France. In other words, no evidence to justify a trial in Canada. That's the test for extradition. There was no evidence to justify putting him on trial, except for one contentious, highly contentious piece of evidence, and that's the handwriting opinion by a French person. It was identified as, even in our courts, as weak, suspect, convoluted, confusing. Those are words that the courts used. And even that it made no sense. It was criticized by the world's leading experts from Canada, the United States, England, and Switzerland on handwriting as being totally unreliable and unworthy. But nevertheless, the courts in Canada said it's just enough to send him to France. During that 3 years that Hassan was in France, two professional investigative judges, highly respected, two of the top people in France, conducted a thorough investigation because the case had come under such international scrutiny. And they concluded, after discovering evidence at the University of Beirut, that at the University of Lebanon in Beirut, documentary evidence and eyewitnesses that Dr. Diab was actually in Beirut writing exams and studying for them at the time that the bomber, the 12-day period the bomber was in France, from September 22nd to October 3rd, 1980. They also produced evidence from the Kopti family that Hassan was in Beirut and drove Nawal Kopti and her father to the Beirut airport, again during that period, on a date where he could not possibly have been the bomber or in France. And that was confirmed by passport evidence. Together with all the scientific fingerprint evidence, the bomber's fingerprints on a police statement, the bomber's fingerprint on a hotel card that the French concealed from the Canadian courts here, claiming there was no fingerprint when actually there was. They knew there was, and they knew it was not Hassan Diab. He was excluded. All of that evidence, the French investigative judges ruled, was so compelling, and they compared it with this weak, convoluted, suspect, unreliable handwriting opinion, and they said there's simply no evidence here to justify a trial. That led to the order of unconditional release and Hassan's return to Canada. Now, at that point, why did a trial ultimately result? There was enormous political pressure put on in France. There were 23 what are called civil parties, unlike in Canada, where a criminal case is between the Crown and the accused person. In France, anybody who has been allegedly injured or has an interest is a party. And there were a number of groups, lobby groups, and individuals, all of whom had lawyers, and they brought enormous pressure and appealed the result of the investigation. And they got the Court of Appeal in France, despite the Advocate General of France opposing this, which was unprecedented. French authorities were stung by the international criticism of their handwriting opinion, so they had two more French experts examine the opinion that had been used in Canada. And that report, shockingly to them, came back that and the two experts in France said, we agree entirely with the defense experts that this handwriting opinion is totally unreliable. It didn't even use proper handwriting analysis procedure. So the Court of Appeal simply ignored that. In a very telling sort of confabulation, they created a fictional trip by airplane from Beirut to Paris on October 3rd, 1980. They said it was still possible, although there was all this evidence that he was in Beirut at the time from multiple sources. He could have just slipped away for a few hours on the 3rd rather, flown to Paris, committed a bombing, and flown back, which conveniently and foolishly overlooked the fact the bomber was known to be there since September 22nd, was seen in a hotel, was identified by the police, was stopped by the police for a shoplifting, and the court simply ignored all that. And the entire French case was premised on the bombers having come from Spain by train. So this was totally made up. It was pretty shocking and, quite frankly, unworthy of an appellate court. So there was new evidence. It was all exculpatory, proving innocence, justifying the decision of the French investigative judges. Not only was all the new evidence and evidence of innocence ignored, but two opinions, inadmissible totally in Canada. A journalist was called, and his opinion was that when he encountered Dr. Diab teaching at Ottawa U and told him he was being investigated for a bombing, Dr. Diab, responded very calmly that this must be a case of mistaken identity, that he was never part of any bombing and not in Paris in September, October of 1980. And it was his opinion as a journalist that an innocent man would have been outraged, and his calm demeanor in answering convinced him this man was guilty. Now it's so remarkably inadmissible that one would have thought that would have no weight. It certainly would be inadmissible in Canada, the US, England, most democratic justice systems. But it was admitted and is admissible in France, and was coupled with the opinion of an intelligence officer who gave his opinion of guilt. And that was evidence that was not used here in Canada because of its obvious inadmissibility. So against all the admissible evidence, the court preferred inadmissible evidence, admissible in France, but inadmissible elsewhere in the world, for good reason. It's unreliable. And all the reliable evidence was ignored, and in quite an unusual and exceptional occurrence, the two professional investigative judges, two of the most highly respected terrorism investigators in France, came to the court to testify that you can't possibly validly convict this man. There's no valid basis for a conviction, and the court ignored them. If Hassan was ever extradited, they would have to do the trial again with the person present. So it's not a final verdict. It's sort of an interim verdict. As terribly flawed as it is, there would have to be a trial. The problem is France admits unreliable, inadmissible evidence in our system against people unjustly. Whatever the motivations, whatever the pressure, whatever the backroom discussions about what was going to happen in this trial. It was not a fair trial by Canadian standards, by most world standards, and it was not a just result. Requests for extradition interstate are secret. They're made confidentially. And if they're refused by Canada, it remains a secret. So either France has never made a request, or because the case is so terribly weak, and they're just going to let it lie, having placated these groups who wanted a scapegoat for what happened on October 3rd, 1980. Or the Canadian government is not going to be party to this again. The problem is that's a political decision as much as a judicial or Justice Department decision. And orders from the Minister of Justice to proceed or not to proceed might override a Justice Department opinion that there's no valid case here. So we live in a kind of limbo. If there was a renewed request for extradition, there are now many grounds for a stay of the proceedings that didn't exist or weren't known to us when we first litigated this case. One is, for example, the violation of international law for cruel, inhumane conduct. Jailing a person for years in solitary so far exceeds the 22-day Mandela Rules international standard that it's shocking. Lying, a state, France, misrepresenting to Canada in the record of the case document on which the extradition stands or falls, misrepresenting the evidence critically, saying there's no fingerprint on the hotel card when they knew there was a fingerprint, and they knew they'd tested it against Hassan Diab, and they knew he was excluded. Those are just two examples of how the Charter would arise in a Canadian extradition to say, you can't possibly proceed. This is shocking behavior.